Look, nobody likes to think about their own death. It's never pleasant, right? But planning for it is honestly one of the most considerate things you can do for the people you love. So today, we're going to break down how to prepare your final affairs right here in South Africa. We'll turn what feels like this huge, overwhelming task into a really clear, manageable process. And it all starts with a simple but pretty powerful question. It's a heavy question, I know, but it gets right to the heart of why we're even talking about this. You have to imagine, in the middle of grieving, the absolute last thing you'd want for your family is some kind of confusing, stressful scavenger hunt for documents, for passwords, and for your final wishes. And that is the core problem we're trying to solve. Getting your financial and personal affairs in order, it isn't just about being organized for the sake of it. No, it's about protecting your family from a mountain of paperwork and uncertainty when they are at their most vulnerable. So, what actually happens if there's no plan? Well, the law has a default setting, and trust me, it's probably not what you would have chosen for yourself. This is where we run into a really critical legal concept. The key thing to understand here is the total lack of personal choice. When the Intestate Succession Act kicks in, it carves up everything you own among your spouse, children, or other relatives based on this strict, unfeeling formula. Your best friend who you promised your vintage record collection to? Sorry, they're not in the formula. That special heirloom you wanted a particular child to have? Not guaranteed. The law decides everything, not you. So how do you take back control? How do you override that default setting and make sure your wishes are actually heard? Well, it all starts with one single foundational legal document. And you gotta understand, a will isn't just a suggestion. It's a legally enforceable instruction manual for your estate. Here in South Africa, it's governed by the Wills Act, and this document is literally your voice after you're gone. It makes sure your assets go to the people and the causes that you actually care about. Okay, so for your will to be valid, for it to be worth the paper it's written on, it has to meet three totally non-negotiable requirements. First, it has to be in writing. No verbal, I want you to have this, will work. Second, you, the testator, have to sign it at the very end of the document. And third, and this is where a lot of people mess up, two competent witnesses have to physically watch you sign it, and then they have to sign it themselves, all in the presence of each other. It's a very specific little ceremony, but it's what makes the whole thing legally sound. And there are a few extra rules to keep in your back pocket. You have to be at least 16 years old to make a will. But the most critical rule, the one that can cause huge problems, is that your witnesses cannot be people who stand to inherit anything from the will. If they are, they could lose their inheritance completely. It's basically a safeguard to prevent any kind of pressure or funny business. So bottom line, always, always choose neutral witnesses. All right, so the will is the legal cornerstone for your assets. But you know what? It doesn't cover the immediate day-to-day practical stuff your family's going to face. For that, you need something else entirely. Here's the best way to think about the difference. Your will tells the master of the High Court what to do with your house and investments, but your ready to depart file, that tells your partner how to pay the electricity bill, where the car's title is, and who your financial advisor is. See? One is for the legal distribution, the other is for immediate, practical navigation. And what should you put in this file? Well, here are some of the absolute essentials. We're talking copies of key documents, lists of all your accounts, your policies, and critically, the contact details for the professionals who can help your family out. Just think of it as the ultimate in case of emergency folder for your entire life's admin. Now, let's clear something up because this confuses a lot of people. Your last will deals with your stuff after you passed away. A living will, on the other hand, it speaks for you when you were alive but can't speak for yourself. It answers those agonizing questions about things like life support and medical intervention. It gives clear guidance to doctors, and maybe most importantly, it relieves your family of an absolutely immense emotional burden. Okay, so we've covered the physical paperwork, the legal documents. But let's be real. In today's world, a huge part of our lives exists online. So what happens to all of that? Wow, this quote it nails it. Think about it for a second. How do you reset any password for pretty much any account? You get a link sent to your email, right? So if your family can't get into your email, they are locked out of almost everything else. Banking, utilities, social media, you name it. Trying to get access to official channels can take months, if they grant it at all. And this right here is the modern trap. It's the ultimate catch-22. Even if you've neatly written down all your passwords for your family, Two-factor authentication can stop them dead in their tracks. That one-time PIN gets sent to your phone. But if they can't unlock the screen, it's a digital dead end. Your password alone is suddenly useless. So, what's the takeaway? It means your digital plan has to include these key details. Your phone's screen lock PIN is now just as important as your bank password. And check out that last point. Platforms like Facebook and Google now let you proactively set up a legacy contact. It's such a simple step you can take right now to give someone you trust control when the time comes. Okay, so let's say you've done all this. You've got your will, your ready to depart file is sorted. What does the official government process of actually winding up an estate look like? And what's it going to cost? Well, the moment someone passes away, a clock starts ticking. And it's fast. The law requires that an estate be formally reported to the Master of the High Court within just 14 days. That is a very tight deadline to meet during a time of incredible grief. Now, what happens next all comes down to one magic number: 250,000 Rand. If the estate's value is below this, the process is way simpler. It's managed by a representative with what's called a letter of authority. But if it's over that amount, the full, formal, and much more complex legal process kicks in, and that requires an official executor with a letter of executorship. And here's something you absolutely need to prepare for. This whole process is not free, not by a long shot. There are a number of costs, fees, and taxes that are all paid out of the estate before your heirs ever see a cent. And this can really significantly reduce the final amount they end up getting. Just take a look at this table for a second. It really paints a picture. The executor is legally entitled to a fee of up to 3.5% of the gross value of the estate. Then you've got master's fees, and there are even mandatory advertisement costs. And for the bigger estates, those over 3.5 million Rand, estate duty, which is basically an inheritance tax, kicks in at a massive 20 to 25%. Believe me, these costs add up incredibly fast. You know, this quote, I think it just reframes this whole topic perfectly. Planning your estate isn't some morbid, box-ticking exercise. It's a final, profound act of love. You're giving your family the gift of clarity, the gift of peace of mind, right when they need it the most. You're leaving them a map to follow, not a mess to clean up. And that really brings us to the final question, which is, well, it's really a call to action. It's a prompt to start drawing that map today for the people you love. Is yours ready?